in terms of sort of some final thoughts from both of you, I know we heard some from John, but Anne, would you like to give your final thoughts? And John, if you want to add any more, then feel free to do so.
Sure. We've got another slide on final thoughts, I believe. And it's repeating it. You guys have now heard me say this 100 times, but these are, basically knowing how to collect the data and leveraging the ability to do it remotely and transfer it more securely, and just less touches, less opportunities and places for people to claim that something got changed. That people like my firm, we're seeing the value in providing the service and getting it done, because then we know when we move on to the rest of the process, when we're trying to find the documents and understand them and all of that, we've got the information from the starting point, what we got and how we got it, and we have some confidence that what we're working with moving forward is what we need and it's the right thing. The certification is right there. There's none of this scrambling later. And this piece about lawyers knowing how to use the technology to find what needs to be found. I think this is really big. And I do it, and I see it in my own lawyer brain, and I see it happening with lawyers that I work with and work for us. It's not every lawyer loves it. Not every lawyer really likes to dig into a database and connect the dots, and we call it hound dogging the data. What do we know? Who's who? Where's the chronology? Let's build the story, figure it out, and feed that to the law firm working on the case, so that the lawyers that are litigating and defending, they get a package, and they don't get a document dump, or they don't have to figure out the documents. We do that for them. And I could see this as work that could be great work for a lot of talented lawyers. And it's work that could be done anywhere in the world, and it can be done at any time of day or night. So people who are struggling or juggling, family issues or other issues, it's a new world. And I would love to see with us get to that place where all those talented lawyers can do this work, and the people who need these documents to be understood and analyzed can benefit from that. And the whole system is better off, because, again, you don't have people settling cases because of the discovery costs and things like that. John?
Yeah, Anne, I think that I really have nothing to add to that, except,
you have a slide. You have a slide. Yeah. Come on,
I do have.
Yep.
I do have a slide. Oh, okay. All right. Well, we kind of went over this before, but this basically discusses the logistical or procedural aspects of the rules, and we have discussed this, and we need to have, obviously, the certification. The certification needs to be made by a qualified person. So again, we've talked a lot about this, and certainly, a reasonable discovery would be a qualified person and their staff and team. Now, there are times where you may actually need several declarants for the certification. You need somebody in-house, and you would also need, an outside expert. But in the vast majority of the cases, an outside IT e-discovery vendor, like Reasonable Discovery, can provide that component, that qualified, person to testify. Now, the opposing party then determines, again, we talked about this, whether it has a meritorious challenge to authenticity of evidence, and if they don't timely object to the certification, then we don't need to waste time having an authenticating witness at trial. And, in this day and age, in particular commercial litigation, in particular, in federal court, a lot of times, and, when I started practicing, back in the dark ages 25 years ago, there was a lot of time wasted throughout the entire discovery, at trial and through the entire discovery process, dealing with, whether it's, records custodians or whomever, dealing with, authentication. So what you have is, you have a lot of judges, a lot of courts, district courts that require you, and I can say that the Middle District, that's the one I practice in the most, the Middle District in Florida, which is the second largest district in the United States, goes from Jacksonville all the way down to Fort Myers, they have a policy where they want the parties to make a diligent effort to attempt to stipulate to and the actual standard to as much evidence as possible, to the authenticity of as much evidence as possible prior to trial. So if you're going to challenge the authenticity, I understand rules, local rules differ from court to court, but in general, if you're going to challenge the authenticity of a document, then you need to have a pretty solid basis. And of course, the other things we talked about is you need to be diligent about obtaining, about providing notice to the opposing party that you have the certificate. And again, lastly, it doesn't just apply to disputes regarding authenticity. But I mean, hopefully these issues are going to be worked out and identified well in advance of trial. So again, this kind of goes back to my general takeaway, and that's sooner rather than later. Identify the ESI as soon as you can. Identify what it's going to take to authenticate the ESI, and one thing I can't stress enough: retain an e-discovery vendor, an IT expert, as soon as you can in the process. I mean, right when you make your your appearance in the case, right when at the very beginning of the lawsuit, retain an e-discovery vendor and get them involved in the discovery process. And that would be, I guess, my takeaways.